Welcome to Is Your Website ADA Compliant from Silvertech. We are a digital experience company specializing in helping our clients create valuable digital experiences for their customers. Website and mobile development, digital marketing and strategy, user experience design, Salesforce development and integration, marketing automation, application development, and managed services and hosting, all united by our lead to loyal approach. Today, we'll be discussing a brief history of the Americans with Disabilities Act, the ADA, website accessibility, and lessons from recent cases, the World Wide Web Consortium, W3C, and the Web Content Accessibility Guidelines, WCAG, accessibility as a best practice, and why website accessibility is difficult to maintain. I am your host, Ian Hughes. I am Silvertech's content marketing strategist. I also host the Lead to Loyal podcast and write for the Silvertech blog. I am very excited to introduce Silvertech's experts. They both bring a unique perspective to the issue of website accessibility. First, Paul Cream, Vice President and General Counsel. With over 30 years of experience practicing law, Paul works with our senior leadership to ensure that Silvertech is consistently pursuing strategic goals, as well as providing day-to-day contract review. Welcome, Paul.
Thank you.
Also on the webinar today is Andrew Eddy, our Engineering and UX Manager. Andrew's extensive background allows him to ensure that all of Silvertech's designs are cutting edge and pushing industry norms in order to deliver the most innovative user experience for our clients. Welcome, Andrew. We are here today to discuss the ADA and website accessibility, but it'll be helpful to first begin with an introduction to the Americans with Disabilities Act. Signed into law in 1990, the Americans with Disabilities Act, ADA, gives civil rights protections to individuals with disabilities, similar to those provided to individuals on the basis of race, color, sex, national origin, age, and religion. Importantly, it's a civil rights law. It guarantees equal opportunity for individuals with disabilities in public accommodations, employment, transportation, state and local government services, and telecommunications. Paul, essentially the purpose of the law is to make sure that people with disabilities have the same rights and opportunities as everyone else. Is that correct?
Yes. Also, it's a law that also guarantees equal access. So you can think of it in two ways, both rights and opportunities, but also access.
In 2008, the Americans with Disabilities Act Amendments Act, ADA-AA, was signed into law and became effective on January 1st, 2009. The ADA-AA made a number of significant changes to the definition of disability. In 2018, it is expected that the Department of Justice will issue regulations regarding website accessibility, but more on that a little later. To add further clarity, the U.S. Attorney General signed the ADA Amendments Act final rule with an effective date of October 11, 2016. In summary, the ADA Amendment Act is intended to broaden the definition of disability. Paul, what does it mean for ADA cases that the question of whether an individual's impairment is a disability under the ADA should not demand extensive analysis?
Well, actually, when the ADA was first passed, the definition of a disability was fairly well understood. It was a major life disability or major life activity being impaired. Mm-hmm. Over the years, the courts have had, on a case-by-case basis, narrowed the definition. So in 2008, the ADA was amended, the ADAA, and there were significant changes were made to the definition. And then again in 2016, again in response to courts, again narrowing the definitions on case-by-case basis, they expanded the definition. So now if somebody's bringing a case, the burden or the first part of the process in the litigation process, which is to survive either summary judgment or a motion to dismiss, is not going to be that difficult. In other words, the burden is not that heavy to carry. So the case will go forward in almost every case.
Due to uncertainty about the meaning of physical and mental impairments, the term is now illustrated with the additional examples of dyslexia and attention deficit hyperactivity disorder, ADHD.
Yeah, to add to the answer too, in other words, when you're now not surviving or getting the case dismissed quickly, your costs of litigation obviously increase dramatically.
Here's a key takeaway. In other words, the person making a claim may not have to carry as heavy a burden to prove their claim. So, who does the ADA apply to? In short, businesses covered by the ADA are Title I, which refers to equal employment opportunity for individuals with disabilities, and that's private employers with 15 or more employees. There's Title II, which refers to the non-discrimination on the basis of disability in state and local government services, and that's public entities at state and local levels, which includes both physical and programmatic access to all programs and services offered. Then there's Title III, and that refers to the non-discrimination on the basis of disability by public accommodations and in commercial facilities. That's businesses operating for the benefit of the public and nonprofits. In regards to website accessibility, the Department of Justice had promised guidelines in 2016, but focused first on entities covered under Title II, and that's those public entities at the state and local levels. On to the ADA and website accessibility. Here's excerpts from a statement from the U.S. Department of Justice, Fall 2015. The ADA's expansive non-discrimination mandate reaches the goods and services provided by public accommodations using internet websites. The inability to access websites puts individuals at a great disadvantage in today's society, which is driven by a dynamic electronic marketplace and unprecedented access to information. Paul, I think this is a telling part of the statement. Beyond goods and services, information available on the internet has become a gateway to education, socializing, and entertainment. Thoughts?
Well, I think any business, but especially schools, financial institutions, or any entity that is selling goods and services through their internet website or their website needs to understand that they need to be just as accessible to people who are coming through their website portal as they would to be coming up to the building itself. So in other words, people have a right to attend classes, so they have a right to attend classes online and have the same ability to attend classes as they would if they were sitting in the room.
Right.
If they're engaging in financial transactions, they need to have the same ability to engage in the financial transactions as they would if they're walking into the bank. The same with people selling goods and services. They have to have the ability to acquire those goods or those services in the same way they would if they were walking into a building.
Right.
So the way to think about it is your building needs to be accessible. It has to have wheelchair ramps. It has to have braille on ATM machines. And it has to have all these assisted devices to help people with certain disabilities. Your website has to be just as accessible.
Similarly accessible. Yep. Briefly now, I'd like to touch on the Section 508 amendment to the Rehabilitation Act of 1973. Section 508 was enacted to eliminate barriers in information technology, to make available new opportunities for people with disabilities, and to encourage development of technologies that will help achieve these goals. Now, there's nothing in Section 508 that requires private websites to comply unless they are receiving federal funds. But it does point us toward what may be commercial best practices, and those include voluntary standards and guidelines such as the World Wide Web Consortium's W3C, Web Accessibility Initiative, WAI. So, guidance is due in 2018 for private websites covered under Title III. In the meantime, Paul, we're seeing website ADA compliance is being enforced on a case-by-case basis. Tell us what you're seeing in states like Pennsylvania.
Well, at this point, we have been, in fact, contacted by some of our clients who happen to be located in Pennsylvania. There are certain law firms that actually make a practice out of targeting certain institutions. Sometimes they're banks, sometimes they're educational institutions. And in many cases, they have one or two people that they use as plaintiffs, and they send a demand letter. The demand letter is an attempt to achieve a quick settlement. And again, if in fact you don't make the quick settlement, then they threaten to take action and file a suit. And again, as I said earlier, it is now increasingly difficult to get a judge to dismiss a case based upon the ADA claim because, again, the burden is not that hard to carry.
Right.
And just because there's no guidelines in place, that does not mean that there's still a need to have accessibility. In other words, the ADA is the law. The guidelines are merely going to be used as a possible defense down the road.
Sure.
If in fact you meet these guidelines, you may in fact then be able to react to the first settlement claim or the first letter that comes in and say, our website meets these guidelines, we're okay. So in other words, just because the Department of Justice has not come out with the guidelines does not mean that you may not receive a demand letter or you may not be sued because your website is not accessible. And if you think about it, your website should be accessible. You want to appeal to as many people as possible.
Sure, yeah.
You don't want to limit your audience by not having a website that's accessible.
Exactly. And here's our key takeaway. It is a certainty that at some point you may want to make your website ADA compliant. Now, Andrew, one of the difficulties, and probably why there's been delays in guidance, is that, and we'll see this when we look at some cases, applying real-world rules to the internet can be tricky. Care to elaborate?
Yeah, so politicians are kind of notorious for trying to impose rules to the internet, and I think, without fully understanding the impact themselves.
Right.
They're not technical people for the most part. So you get kind of, some of the goofier examples from several years ago, where there was rumors of the United States Postal Service thinking about putting postage onto emails, and then you have kind of a much more serious recurring theme from the FCC of net neutrality. But as Paul has mentioned, the internet's intended for accessibility, and the point is to eliminate barriers for communication and to gather information. So not only would compliance help, people with disabilities, but it helps all users that would be accessing your website.
Exactly. So moving on to the ADA, website accessibility, and lessons from recent cases. Now, we're not going to dive too deep into the specifics of each of these cases. We've chosen just a few that might give some insight into what the Department of Justice 2018 guidance will be. The National Federation of the Blind versus Target Corporation. Target argued that the website was not a place of public accommodation. However, the court found it is clear that the purpose of the statute is broader than mere physical access, seeking to bar actions or omissions which impair a disabled person's full enjoyment of services or goods of a covered accommodation. Paul, the key takeaway here, a website may be considered a place of public accommodation.
Well, I think we've pretty much covered it. And again, I think every entity needs as we said, think about their website is a replacement of and eventually possibly their only way they're going to interact with customers.
Sure.
So accessibility is going to become not less important, but more important as time goes on.
Exactly. Now, what if you don't have a physical location? You might be thinking that the ADA will not apply, but there is precedent for such application. Netflix's Watch Instantly website was a public accommodation subject to the ADA, even though Netflix has no physical place of public accommodation. The ADA covers the services of a public accommodation, not services at or in a public accommodation. Paul, key takeaway here, obviously you may not need to have a physical location to be considered covered by the ADA.
Well, that's correct, and there's a lot of businesses that don't have any physical locations anymore. Amazon doesn't have a physical location.
Sure.
So I think that's, again, it's going to become an issue, and I think anybody that's going to be transacting business or providing services through their website is going to have to be cognizant of these guidelines.
Absolutely. Now, the last case we'll take a quick look at is the Department of Justice Peapod.com settlement. This settlement shows that the Department of Justice is looking closely at the accessibility of websites and mobile apps and remains aggressive in its enforcement efforts. And at a minimum, the Department of Justice may require companies to comply with WCAG 2.0 level AA standards. First, Andrew, thoughts on mobile applications falling under the ADA? Level AA standards would be difficult to maintain there, right?
Yeah, a little bit. So, I mean, you have to think about mobile applications a little bit. So there's fundamentally kind of two different kinds of mobile applications.
Sure.
There's the kind that runs natively on your phone. You go to basically it was built for the device that it runs on.
Sure. Yeah.
So just all sorts of examples where they would essentially be using the phone's operating system to help assist them in providing compliance and accessibility features to the user. There's also mobile applications that are accessible from both a mobile device and a computer. So you have essentially, and there's kind of two different versions of that without getting too technical. But there's essentially there's ways you can build mobile applications that essentially just wrap around a website. You can still click the icon on your phone and have it pop up on the phone, but it's essentially serving a website kind of under the hood. Those would follow all the WCAG and
Sure.
Section 508 and the other different types of compliance. The native applications themselves would have to be built in a little bit of a different way to take more advantage of the actual phone's hardware capabilities
Sure.
and the accessibility that's operated through the operating system.
And by that you mean, like, I can go to the settings on my iPhone and increase text, that sort of thing?
Correct.
Okay.
Yep.
And the application would just have to be
Yes.
built in a way to allow that,
Yep.
your system settings to make it compliant.
Exactly,
essentially.
and if the application itself isn't native, then you can start taking advantage of more of the web technologies to provide the same levels of accessibility to the user.
Interesting, very interesting. Key takeaway then, these recent cases may only be the beginning of the explosion of website accessibility cases. Paul, you've mentioned in your blog that some courts may be increasingly reluctant to dismiss website accessibility lawsuits at the beginning of the case. Cases will continue to discovery. What does this mean?
Well, we saw two recent cases in Massachusetts, which is where we're located next door in New Hampshire, and both were major universities. And in that case, the magistrate, which is the first step in the process, did not dismiss either case. So that means that now the defendant company, or in this case, defendant university, is going to have to either decide to settle, or they're going to have to decide to go through the process of discovery and all the other parts of litigation that become expensive very quickly.
Right.
And in the end, you're going to have to probably fix your website anyway.
Right.
So in other words, just settling the case does not mean that the case goes away or that the website doesn't need to be fixed or updated anyway. It just means that you've now added an additional cost. So in my mind, the fact is if you think you're going to get sued and you think you're just going to get rid of it right away and you're just going to continue to go on about your business, that's probably not going to occur. What's probably going to occur is if somebody targets you and they're probably going to at least win that first step, and then you're going to have to update your website anyway.
Right.
So the best practice would be proactive.
Right. I'd like now to introduce the World Wide Web Consortium, W3C, and the Web Content Accessibility Guidelines, WCAG. This is where I think we'll find insight into what the guidance ultimately will be from the Department of Justice. So, leading the web to its full potential, the motto of the W3C. So, the Worldwide Consortium, or W3C, was founded in 1994 by Tim Berners-Lee, often credited as one of the founders of the World Wide Web. Andrew, your thoughts? Since the beginning of the internet, it has been about granting inclusive access to information to as many people as possible.
Yeah, I mean, the internet has always been, it's essentially always been about providing an open platform to provide information, as you said. If your site is not in compliance, no matter what, you risk segregating the user base that's coming to visit your website. If you look at that from kind of a business perspective, that's potentially missing out on leads and conversions.
Sure. Yeah.
But fundamentally, if it's the guidance and the guidelines that they're putting in here, and we'll get into this in a little bit. I mean, it's not just solely about users or providing access to users with disabilities. It's best practices as you're building a website, and then the actual guidelines that they enforce within these standards. Will then on top of that provide access to people that would normally have trouble visiting your website. So really it's about being inclusive in terms of delivering information to the users coming to your website.
Excellent. Well put. So then, in 1999, the Web Accessibility Initiative, WAI, and the World Wide Web Consortium, W3C, created the Web Content Accessibility Guidelines, WCAG. In 2008, these standards were updated in WCAG 2.0, which has become an ISO international standard for the web. A number of governments already require that public websites meet these standards, including those in the EU and Australia. And, as we saw with the Peapod case, the Department of Justice may make WCAG Level AA compliance the new standard. So, WCAG 2.0 established 4 principles, POUR, for which there are 3 levels, A, AA, AAA. Let's review the principles first. Perceivable. Information and user interface components must be presentable to users in ways that they can perceive. Provide text alternatives for non-text content, provide captions and other alternatives for multimedia, create content that can be presented in different ways, including assistive technologies without losing meaning, make it easier for users to see and hear content. Operable. User interface components and navigation must be operable. Make all functionality available from a keyboard. Give users enough time to read and use content. And do not use content that causes seizures. Help users navigate and find content. Andrew, how difficult is it to build a website and plan for example, making all functionality available from a keyboard?
Honestly, it's not difficult at all. If you could bring up any website in a browser, it could be the most uncompliant website in the entire world,
Right.
and you could sit there and you could literally tab through every link on that entire page. Most browsers have a amount of built-in functionality to try to make websites more accessible without you doing anything extra to your website itself.
Okay.
Again, without doing anything, you can literally tab through everything.
Sure, yeah.
There are certainly ways to help the user and to help the browser interpret this. Use keyboard for an example here. It's literally as easy as adding something called a tab index to different elements on the page. So whether it's menu or form field items, say you build a form and you have first name to the left, last name to the right, and maybe title again on the next line to the left. Well, you would obviously want to go from first name to last name. It's one tag that you put in there, and you would say tab index 1, tab index 2.
Okay, so you can guide with those tags.
Exactly.
Yeah, okay.
Yep. So, the amount of work that it takes to initially set up a website with the majority of the criteria to meet these standards is relatively small.
It is, okay. Then the next principle is understandable. Information and the operation of user interfaces must be understandable. Make content appear and operate in predictable ways, and help users avoid and correct mistakes. The final principle is robust. Content must be robust enough so it can be interpreted reliably by a wide variety of user agents, including assistive technologies. In other words, don't use tags or codes that only certain browsers understand. So, for each of the WCAG 2.0 principles, there are guideline levels A, AA, and AAA. Similar types of accessibility features are addressed in each, with AA having more and AAA having the most criteria to meet the level of accessibility standard. Andrew, how many websites out there achieve AAA accessibility?
To the best of my knowledge, there are no websites
Really?
that achieve true AAA compliance.
Really? Yeah.
It's really more of a it's a goal. It's the highest possible accessibility that you could achieve, and it's there's so many guidelines to it. That you get to a point where they almost start contradicting each other a little bit.
Okay.
With the technology and being able to run in multiple browsers and have omni-channel content delivery and all this, it's almost a hindrance on displaying the website. It basically is a little restrictive of design.
Sure. Yeah.
And how the website itself would operate. But it's kind of the what you shoot for.
Sure, the ideal kind of
and then
full accessibility.
It's probably somewhere in between AA and AAA is where you'd actually end up.
Exactly. So also, businesses do not have to comply with all listed criteria to meet conformance, only those that apply to your website and your audience. For instance, if you don't have video on your website, you don't have to worry about captioning videos. Let's now take a closer look at WCAG 2.0 guidance level AA. The main items are captions provided for audio content, transcripts provided for video content headings and labels descriptive of topic and purpose, the ability of the user to resize text up to 200%, and the navigation features must be consistent. Andrew, could you tell us what it means for content headings and labels to be descriptive of topic and purpose?
Sure. So it doesn't mean that they need to be wordy or lengthy.
Sure.
What it really means is they essentially need to be cues for finding and navigating content. So they're helpful for screen readers and people with vision difficulties. So they'll provide contextual clues essentially. A couple examples might be a table of contents. Where you would have just kind of a massive wall of links.
Yeah.
With obviously there would be a hierarchy, but you just have basically a listing out, or when you need to jump kind of from heading to heading on a website to go from one section to another.
What does it mean then for navigation features to be consistent?
So that's it's pretty much what it says. Where it means that if you have a menu that's at the right below a block on your website, say you have your logo and some material up at the top, maybe a login box or a search box. Traditionally, you would have a menu below that on the majority of sites that are trending now. So what they mean by that is if I click something in that menu, when I go to the next page, the menu shouldn't then be at the bottom of the page.
Right.
So, not only is it, best practices and just standard good design practices for a website, but it also, is less confusion for people with disabilities, for screen readers, for other utilities that would be, following along and helping a user navigate a website.
Excellent. So then I think our key takeaway here: accessibility overlaps with other best practices such as mobile web design, device independence, multimodal interaction, usability, design for older users, and search engine optimization, SEO. Thoughts, Andrew?
Yeah, and I think we've kind of been hinting at this the whole time. The majority of these guidelines are best practices that every website should use. You have the alt and title tags, easily navigable, text resize. Your color and design choices should be in compliance, and just general UX choices that provide a better experience to users. By following the standards, you'll have a better website, even if you aren't specifically targeting compliance.
Mm-hmm. Clearly, then, website accessibility is a best practice. So, here are some best practices that will help you achieve level AA. Do not rely on color as a navigational tool or as the sole way to differentiate items. Andrew, could you clarify this point? There are certain color ratios that you should strive for.
Yeah, that's mostly targeted for people that are colorblind.
Sure, yeah.
So if you have a header at the top of your page and say you have a menu, and that menu is green, and the text you put on it is red.
Yeah.
Well, some people just would look at that and not
see
see the text.
Yeah.
There's varying levels of color how colorblind people are, and there's standards that they introduce where everything from using colors that are too close together or colors that are known kind of for troublesome for people that are colorblind, and it goes all the way up to having a high contrast mode, where you can kind of flip a button and have a lot of the colors on the website essentially go from very different.
Sure. We'll show an example of that in a bit.
So you'd have some darks and lights and things that wouldn't be confusing for a user.
Interesting. Moving on then, images should include alt text in the markup code. Complex images should have more extensive descriptions near the image. And Andrew, we were talking earlier and you brought up a good example. If you have an image on your site and it's a picture of a guy, your alt text shouldn't be picture of a guy. Care to elaborate?
Yeah, you want them to be contextual. As you just mentioned, if you have an image sitting there and it's picture of a chair.
Yeah.
Well, what kind of chair? What, could you give me what color is the chair? How big is the chair? Some contextual information that provides not just what the picture is, but valuable information about the picture, so that somebody with vision impairments can get a sense of what's being displayed.
Supposed to be there. And you mentioned too, then it's not just for the vision impairment, but what if the image doesn't load?
Say your CDN. Well, say your CDN goes down, or it's being hosted somewhere else, and that goes down. It's just general good practice to have relevant information displayed about an image when you're putting it onto a website.
Right, makes sense. So Functionality should be accessible through mouse and keyboard and be tagged to work with voice control systems. You should provide transcripts for your podcasts. If you have video on your site, you must provide visual access to the audio information through in-sync captioning. And site should have a skip navigation feature. I wasn't sure what this meant. Andrew, could you clarify this point?
Yeah, it's the main point of it is to bring users to the actual content onto a page.
Sure.
So I mean, if you look at a kind of an average website now, you have search boxes, you have navigation, you have tertiary navigation, you have secondary navigation, you have a mega menu. So all these elements, and some of that stuff can be very confusing for automated processes as it's going through. You can have a bulk of a website without even really knowing it in the header of the actual site.
Yeah.
So what this does is essentially make it easy for people to kind of move past that and get to the actual content that they're looking for.
Excellent. Yep, we'll get to. I have an example of that too as we move on. We at SilverTech, we have worked with hospitals, public universities, financial services institutions, and utilities that required level AA WCAG compliance on their websites. As long as the site is planned and built with requirements in mind, it typically is not a big deal and is achievable to that level. Let's take a look at a site with accessibility features we recently launched for the Granite State Independent Living. Here's a closer look at the toolbar. You can see that a visitor has the option to resize text, turn the contrast on or off, use text navigation only, and skip the navigation altogether. Here you can see that the text has been resized 200%. And here's the contrast setting that accommodates users with vision difficulties. Here's the text navigation only feature. And finally, a look at the skip navigation feature we were speaking of. Andrew, now this is not necessarily covered under the level AA guidelines, but homepage image rotators, those carousels, they're ubiquitous on banking websites, healthcare websites, higher ed websites. Usability best practice, I mean, they present information rather fast. Does it make sense to consider building your website without homepage image rotators?
Yeah, it does. Aside from just kind of the standard analytics that you can type in, are carousels useful into Google?
Yeah.
And you're not going to see very positive results on that. So, aside from the entire conversation about, compliance, carousels by nature are not intuitive to users, and most images past the first one, I think it's some sort of crazy statistic, like 98% of the rest of information in carousels never either gets seen or clicked on. You kind of add in the fact that somebody visiting this might have a hard time with it, and you're really kind of steering somebody away from your website in general.
Yeah.
Between kind of the flickery nature of it, as you mentioned, the fast-moving images, the need to click on different arrows to navigate where you are, it's not exactly compliance-friendly.
I agree. Thank you. Now, let's conclude with a brief discussion on why website accessibility is difficult to maintain. We find that although sites may conform to level AA guidelines when they first launch, most companies do not have governance in place to maintain it over the long term. Why is this?
Most of it's just kind of a matter of maintenance.
Yeah.
There's a couple different reasons. You may have had an agency or something outside of your company produce the website for you. Sure. It might have been delivered compliant, and then over time, most kind of repeat offender on this is content entry. Yeah. So the more you add to the website, the more you need to make sure that what you're adding to the website are meeting the same standards that was delivered. And the average thing that a user will miss is the alt tags, the title tags.
Yeah, I was going to say, yeah.
And kind of the different elements that live within the content itself that would keep the website consistent with its compliance. And there's different tools out there too, though, that users can take advantage of, with different content management systems.
Sure, I'm thinking the alt text example there. I imagine most modern content management systems are going to prompt you to enter in that alt text when you upload that image.
Yeah, exactly.
So That's one of the many benefits of these modern content management systems, is that they will kind of keep you in compliance. And two, as you said, it's content, so it's also an issue of, kind of these content management systems will allow you to have a workflow and kind of an approval process in place, so you can set, a governance policy and then just make sure that you're following through.
Yeah, you can put your checks and balances around it. Kind of have somebody review work before it goes out. You can set automated processes on it. A lot of the content management systems now, when you hit publish or save, it will automatically run a check on the content and then either stop you from publishing if it's very strict, or it would alert you to all the warnings and request that you go back and fix them before the content actually goes live.
Excellent. Paul, here are some of the recommendations you make to clients. You recommend that clients create site governance policies that list out requirements for all content types and site modifications. Additionally, the site should be audited on a regular basis, either by a knowledgeable web development agency or a knowledgeable internal site owner. And just as new ADA laws come into effect, WCAG standards change on a regular basis as well. Upkeep is important. Now, I think this is the key takeaway of today's presentation. By making your website accessible, you are ensuring that all of your potential users, including people with disabilities, have a decent user experience and are able to easily access your information. By implementing accessibility best practices, you are also improving the usability of the site for all users. And this is from usability.gov. Andrew, thoughts?
Yeah, I think they hit the nail on the head. Aside from any legal issue that you may encounter either now or down the road from this, I think the point is simple, that you are providing a medium for users to be able to access, and you want to be as inclusive as possible to the users that you expect to come to your website.
Well said. After the webinar, we will follow up with a full presentation, copy of our presentation that we put on today, and I will be sending out an ADA website accessibility checklist, so you can look for those in the coming days. But let me see, it does seem that we do have a couple of questions here. Let's see if we can take this one from Adam. Do captions and transcripts need to be provided for videos from third-party sources such as YouTube? Thoughts there? We might have to dive a little further into that. That's a question from Adam on the line here.
That's a little bit of actually a very interesting question. YouTube has the ability to add closed captioning, but you also have to take into account that that's user-submitted content. So YouTube itself isn't generating these videos and posting them on their website. It's aggregated from users themselves. So I would imagine that would fall into a little bit more of a gray area if YouTube, for example, was audited for if they're in compliance. The material that YouTube themselves, and Paul, you can probably speak to this a little bit better, but I would imagine that with YouTube would be responsible for the code and the experience that YouTube delivers, whereas the user-submitted content is probably a little bit more in a gray area.
Yeah, I can add to that a little bit too. A lot of times when you put terms of use on your website, you can in fact actually disclaim any liability or any responsibility for anything that comes from a third party. So in other words, if somebody links to another page through your website, for instance, or someone loads things onto your website from another source, you can specifically state in your terms of use that there is no responsibility on behalf of your company for that particular application.
And would that apply to, Paul, if you had a YouTube video that your company had made on their YouTube page embedded on your own website?
Well, I think in that case, probably the better bet would be to make sure there's closed captioning because you're providing.
Yeah, at that point, you're
in my example, it's if in other words, a lot of websites do have links to other websites.
Sure. Yeah, you're sending them off.
You direct someone to somewhere else, and you don't have responsibility for that. So I would look at that the same way as if somebody is putting something onto your website.
Interesting. We have another question here. And this one, I think, Andrew, we kind of were touching on it here, but most web browsers have built-in text size adjustments. Is that sufficient?
Yes, they do have it built in. The way the standards read is that you need to provide a way for the user to resize the text. So would somebody consider the browser as sufficient? I'm not sure, because the website itself can be delivered in other mediums other than a web browser itself. As long as something receives HTTP requests, it can look at your website.
Sure. Yeah. So you're not necessarily coming from your Chrome or Safari. Exactly. Yeah. Excuse me. And I think I hope that answers the question there, Cody. I think then that best practice would be to have that yourself.
I would rather be safe on that.
And then just a final question then, Andrew. What steps do you think you could take today to start on the path to ADA compliance?
Yeah, there's all sorts of online reading and material that you can just kind of gather and read more about on this. I think a starting point, if you're nervous that your website might not meet a lot of the compliance standards that we've talked about, is there's free tools online. Mm-hmm. And you can just kind of Google WCAG 2.0 online compliance check.
Yeah.
And you'll get a bunch of results, and you can run your website, and some are better than others, but you can at least get a pretty good idea
of where you stand.
Of where you stand. Yeah.
Excellent. Good. And hopefully you'll find some value in the checklist that we send out. We will address those level AA guidelines, so you can at least do a self-audit and just run through that yourself. So again, thank you everyone for joining our webinar on ADA and website accessibility. I hope we've at least made the case for your organization to start asking the question, is my website ADA compliant? Andrew and Paul, thank you very much for sharing your insights and perspective on this very important issue. Thank you.
Thank you.
Thank you.
And that concludes our webinar for today. Thank you very much, everyone.